Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm confused on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date and time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are...
Right from the start, this hearing sets a serious tone. 3 charges: fleeing from police, assaulting an officer, and driving on a suspended license. You can see the judge's calm but firm approach. She's spelling out just how much is at stake. And remember, the defendant is representing himself. That's already a massive red flag in a felony case.
I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first day.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right. And under those circumstances, and I forgot, I think you had mentioned that before, that...
Here's where things start to get messy. He's basically saying he didn't get enough time to see the evidence, the body cam videos. But the prosecutor isn't even using those today. That confusion right here shows how unprepared defendants can be when they try to play lawyer inside the courtroom.
But then you were talking about, you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
Gotcha.
prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day. That's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay. So you were trying to do it one way. That wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try that. Okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So we'll need to then adjourn that. Well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, how long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a...
No, that's fair. That's fair.
And then also...
But you don't know total...
Now this part hits differently. You can hear his frustration. He's trying to access legal evidence from jail, but there's red tape, staff shortages, and no real system helping him. This isn't about guilt or innocence yet. It's about how chaotic self-representation can get when you're behind bars.
I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here and telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this up.
The judge tries to be fair. She gives him more time. But what comes next completely changes the tone of the room.
Discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the doctor would hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to amend the information against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. Said meant legally hit the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, you sit there for a welfare check with a possible rolling domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his the talent or the lane system or whatever it is they use in the police cruiser. Make sure to iterate that I plan to use the legal system.
The prosecutor comes in strong, accusing him of threatening to cook the sergeant and even the officer's dog. That instantly shifts the judge's mood. Whether or not it's true, that's the kind of claim that kills any chance of bond. This is the moment the courtroom energy turns cold.
I was very proactive in trying to get this addressed through the court system. Had no intentions of running or trying to avoid it at all. And I think my actions were such.
In this matter, I'm not going to, at this point, change your mind, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I asked you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom. I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are, and I'm not saying you're guilty of them, I'm not saying any of that, but in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay, and so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay? And I would agree, just real quick, and I'll let you.
You can feel how careful the judge is being. She isn't emotional, but her words cut deep. She's basically saying, "You've shown me you're a danger, and your past behavior in this courtroom proves it." This is pure judicial control. Firm, calm, and backed by law.
Would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. Yeah, and I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom or this court for reasons I don't even, Mr. Siren, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
Your Honor. What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. Since there was that misunderstanding, it was adjourned, I believe, four times over those matters. It wasn't because I was acted out on it. I believe I came and went so fast. It wasn't even opportunity.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you?
This is one of the most revealing exchanges. The judge calls him a hothead, and honestly, she's not wrong. It's rare to hear a judge speak so plainly. She's trying to protect him from himself, but he keeps pushing, trying to justify everything.
Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges I've ever had going in front of, whether Traffic or Miss Spink that was able to have a conversation after the court time.
She's nicer. She's nicer than I am.
She's a very nice woman, that's for sure. And
she's much nicer than I am, and so she has patience. Sometimes I don't.
Fair enough.
So you got to take it as it is. All right. Thank you. You do the same.
And that final moment says it all. He compliments another judge for being nicer, and she fires back saying, "She's much nicer than I am." This courtroom isn't about sympathy. It's about control, authority, and law. You can feel the clash between defiance and discipline.